With the basic building blocks in place, we just need to extend some of the concepts we've been dealing with so far. To really understand how the Australian legal system works, we need to understand how power is shared between the two governments, the federal government and the state government. And then we need to know about the different arms of government and what each of those specific institutions do with respect to enacting law within the Australian system. So if we're going to have the rule of law, it means that everyone must act in accordance with the law. This leads to a rather complex situation where there is a law that tells us what laws the government are allowed to make. Or more precisely, there's a law that tells us which government is allowed to make laws about which areas of our lives. And that's in the Constitution. It deals with an issue of jurisdiction, or the right to make and apply laws. And those laws are made and applied through three different arms of government. The legislature, which drafts or makes the law, the executive, which administers it, and the judiciary, which applies it or judges it. So let's get into these concepts. So you'll remember that Australia is a federation. So that means that the power originally was in the colonies. They were self-governing under the umbrella of the British Empire, but they were self-governing. So what actually happens when Australia gets formed? The colonies turn into states, and those states give up some of their powers. They relinquish power. So they decide about things that they think would be better handled on a national level versus things that should be handled on a state level back in 1901, and preceding that when the negotiations took place. So what did they do? Well, they actually didn't go as cleanly as saying the Commonwealth has these powers and the states have these powers. What it actually did was say there are some powers that only the Commonwealth has, exclusive powers. So the states gave up all the power around these areas. So for instance, here's one that might make sense. Military forces. It's the Australian Army. There's no Queensland Army. And in fact, Queensland can't raise an army. It gave that power to the federal government. It gave the power to making a currency, the Australian dollar, not the Queensland dollar. Okay? So there's a whole series of areas where the Commonwealth gained the power. Then there are a series of areas, particularly we can have a look at Section 51 if you're interested, where the Commonwealth was given the power to make laws, but the state retained the power to make laws around those things too. So a relatively recent one where we can see that in play is marriage. That used to be done entirely by the states, and so the issue of, for instance, same-sex marriage varied throughout Australia because the law was based upon what each state said, and some states allowed for it and some didn't. Then there was a growing national push for recognition of same-sex marriage, which ended in a plebiscite, and then the federal government came in and said, everyone can have same-sex marriage. So it previously had not had a say on this, but then it decided that it was going to make a law. So what we can see is that both areas can make a law around concurrent powers. We'll deal with what happens if they conflict, but the issue is both of these jurisdictions can actually make a law about an area of concurrent power. And then there's finally everything else. So if it's not listed as an exclusive power or a concurrent power, then the Commonwealth cannot make laws about anything else. And these are the residual powers, the remaining, right? The residual powers. And these can only be enforced by the state. One way that you can get a hint of what these things are is to think about the departments, the state departments in government. We have a Queensland Police Force, Queensland Health, Queensland Transport, Department of Education, Queensland. And that, for instance, explains why education practices vary by state. So starting age, or there's a whole lot of practices that vary by state. Why? Because the residual power for education is state-based. Now, you may be sitting there thinking, yeah, okay, all well and good, but what's that got to do with business? Well, it can have a huge impact. For instance, just say an area that is regulated, workplace health and safety, regulated at the state level. That means if the states have different laws for each state and you operate nationally, you need to have a compliance system that can account for all these different regulations about the same topic. In contrast, if there's an Australian regulation, you just need to follow one. So these kinds of issues have huge impact on businesses and how they need to run and what they need to do, particularly in areas of compliance. So just to reiterate, the Constitution sets out what the federal government can make laws about. Some of these are exclusive to the federal government, meaning the state can't make a law in this area. The topics that aren't as clear, most of them are listed in Section 51, and they're concurrent powers, meaning both the state and federal governments can make laws. So what happens if there is a conflict? How does this actually operate? Well, if the federal government hasn't legislated the area, then that issue remains within the authority of the states. Now, if the states have made a law and the federal government makes a law that conflicts to it, then Section 109 of the Constitution tells us that the federal government rule prevails to the extent of any inconsistency. So it does mean that the Commonwealth rule trumps the state rule, but only to the point of any inconsistency. This means that neither our federal nor state parliament can make any laws they want to. They have to make the laws in accordance with the split of powers in the Constitution that upholds the rule of law. And you can challenge their ability to make these laws. You can challenge their constitutional validity in the High Court if you think they've done the wrong thing. So even a government is not free to do whatever it wants to do. So far, we've been talking about the two levels of government, and level kind of sounds like one's above the other, etc. But they're really two different governments that we have in Australia, the federal government and the state government. However, within each of these governments, they have different institutions, or some would call it, I think they call it the machinery of government. It's how the government actually operates. So there is one group that makes the law, that legislates, the legislature or parliament. There is a separate group that administers the law. They make sure it gets put into effect. That's called the executive. And then finally, there's another group who interpret and apply the law, and they're the judiciary. So think about it this way. The legislature makes the road rules. For instance, you've got to have a license if you want to drive. Okay, but how do you get a licence? You don't go to Parliament to get your licence, you go to the Department of Transport. So the Department of Transport puts in place all the kinds of systems and processes and things we need if people are going to have to follow that law. They administer the law at the Department of Transport, and so you go get your licence. Now, just say something happens and it's unclear whether you had a licence or you didn't, and you end up in court. The judges are the ones who decide whether you followed the rules Parliament set and were dealt with correctly by the Department of Transport. There's a different body that judges whether, for instance, you followed the rules and the rule of law has been followed correctly by all the parties. So that's why we have three different arms, and they're with both of our governments. So federally, there's a parliament in Canberra, there's the executive, and there's the judiciary, particularly the High Court that we have, okay, and the federal court, and the family court. In Queensland, we have the Queensland Parliament, we have the Queensland departments, and we have the Queensland Judiciary, the highest court being the Supreme Court in Queensland, which we'll get to. So there are actually 6 arms, right? 3 in each. So when we talk about the government, often we have to specify which part and which government are we actually talking about. So as I was saying, the legislature makes the law. We've got the federal parliament and the various state and territory parliaments. That means we have 2 levels of government because of federation. The parliament are the elected representatives that are making the laws for the citizens. That reiterates that principle that we talked about earlier in the earlier video of Australia being a liberal democracy. The laws that Parliament make are called legislation. They're also called Acts of Parliament, and they're also called statutes. Those 3 words mean the same thing. The executive administers the law. They carry on the business of government. In Australia, again, because of that federation, we have 2 executives. The first executive at the federal level, we have the Prime Minister and the other ministers. They're the federal government executive, and at the state level, we have premiers and the ministers for their departments. So the executive implements the law and administers the law that has been passed or made by Parliament. So they do the day-to-day work of making sure that the law is put in place and followed. Now, what you might note here is that the executive in Australia, at least the leadership of the executives, the leadership of this executive, actually comes from the legislature. If you're following along, that is because we are part of the Westminster system, which has as a core the principle of responsible government. So what it's really saying is the people in charge of administering the law should also have to report back to the citizens. And in order to do that, we make sure that they come from our legislature, from the Parliament, so that they have to go back into the Parliament and answer questions from all of our elected representatives. So that's the advantage. We get increased accountability because of that structure. However, it means we don't have a strict separation of powers. If you think about it, we have all of the elected parliamentarians, and then the executive. The leaders of the executive are a subset of the legislature. However, we try and make our judiciary an entirely separate organ and have a strict separation to the judiciary. The third arm of government is the judiciary. They interpret and apply the law when they're resolving disputes. The judicial power is exercised by the courts. Again, we have federation. which means each state and territory has its own court system. There is also a federal court system. So we have those two court systems in Australia. Courts are arranged in a hierarchy from lowest to highest, and that tells us who can hear what matters. What it really means is the most experienced judges hear the most important or impactful cases. So a hierarchy of courts allows for appeals. You can appeal to a higher court. You can have different forms of hearing for cases of different importance. And it also allows for the operation of the doctrine of precedent, which we'll come to later. A core reason for having these three arms is to allow for a check and balance on the exercise of power. If one person can make the law, administer the law, and judge the law, then they can essentially do whatever they want. They can interpret the law the way that they want rather than the way an objective person would. It actually means you end up with a despot or a group, a junta, who's controlling things. So what we look for is a separation of those powers and different people exercising those powers differently to try and stop an autocratic system of control in a liberal democracy. That's why the separation of powers is important for the rule of law. So this idea of separating powers goes back a long way. In fact, you can trace it back as far as ancient Greece and is often attributed to the French philosopher. And a lot of people would suggest that it becomes formalised around the mid-1700s. The basic idea is that our three arms of government should remain functionally separate so that there's a check and balance in society and we don't get an over-concentration of power in any individual or group. That means the same person should not form part of more than one arm of government. One arm of government should not control or interfere with the functioning of another, and one arm should not exercise a function of another. So the executive shouldn't be the judiciary, or the judiciary shouldn't be the legislature. So in some countries like the US, there is a strict separation. Congress is entirely separate from the executive, the president and the secretary of the departments, and that's entirely separate to the judiciary, the Supreme Court. That's not the case in Westminster systems like Australia, where the executive are drawn from the legislature, and that allows for this principle of responsible government and accountability of the leaders of our executive. Both of those systems have drawbacks, and I think you can see a key confusion about the issue. I don't want to get into the politics, but I think a very recent confusion that we've seen over in the US, where President Trump appointed Elon Musk to head one of the areas of government, the DOGE, and people were going, no one elected Elon Musk. Well, yeah, that's how your system works. You elect the president, and the president can appoint whoever they want to run the government, right? It's a very different principle. In Australia, the head of the department would have to have been elected to Parliament. So it wouldn't really allow for that same situation to occur. You could make them a director general, etc., but they would be reporting back to someone who was elected to Parliament, to Congress, not back to the president. Different reporting line. So the system is entirely different around the executive. So you can sit there at first and go, well, why don't we have strict separation? It seems like a better way to go. But you do get these unintended consequences. And one of the things is our system has a history developing over hundreds of years. And there's often very good reasons why things are structured the way that they actually are. We've found that works best if we're going to have a stable, peaceful and prosperous society. Having said that our executive and our legislature are intertwined, there is often a huge issue when we get a mix between the legislature and executive and the judiciary. The judiciary is meant to be strictly separate. So you'll see that there's lots of expectations and protocols about parliamentarians shouldn't be criticising courts because they're separate. They shouldn't be trying to do their job. They shouldn't be trying to influence them, right? Huge issues around that. There was a relatively recent issue of that in Queensland in the appointment of the Chief Justice, I won't bore you with. But we're trying to avoid the elected people in power in Parliament telling the courts what to do. The courts should be able to stop them doing things that they're not allowed to do. So they have to have that power separately. So they're meant to be beyond influence. And the flip side of that is judges shouldn't really be making law. That's the role of Parliament. What do we mean by that? Well, there are different debates about how judges should interpret the law, something we'll get to as we go a bit deeper into this week. But it leads to debates the other way. How much freedom should judges take in making the law? Because no one elected them. You should stick to your knitting, right? Stick to your arm of government. So that is the one big separation in our system. In the real world, there's some controversies around the edges. There's some nuance in how we do it. For instance, how do you get a judge? Well, theoretically, Parliament all agrees. So it's not one political party appointing someone. It should be a general agreement of the major parties together agree that this person would be a good judge. Try and keep that independence. Despite those wrinkles, we do try and keep that strict separation of the judiciary from the executive and the legislature. So we've been through law, we've been through the principles behind our legal system. The one last thing to do is to look at how all of this operates in practice, and we start that in the next video.